Okay, welcome back, folks. After a brief break, we are taking up H 657. We left off on the discussion around locked bedrooms, and um, I don't know if people have had had any further insight during the break. Tyler, are you there? Are you able to come on?
I am.
Hi.
Hi.
So were you able to find out about fire?
The fire doors, no, I did find out about the earlier on about the adjacent materials question, if that's
All right,
still
well,
a burning
let's deal with
question.
that one. That one might be easier.
Yeah, I think so. It wasn't very clear to even our licensing group what that did. They did a Google search to try to figure out what it was
Yeah,
referring to,
okay. All right.
probably referring to like straight jackets or like a sheet or something that is put around somebody's body. It's not something that we use in practice. So.
Yeah, okay. That's helpful. So I think we should um
And
because it's prohibited, but then there are certain things allowable. So we have to figure out a way, Katie, to remove it from what's allowable when it's allowable. So
Okay.
maybe we just separate that sentence and say in no cases shall adjacent.
yeah.
Yeah, it has to, it's referring to things that are attached to walls, or the floor or something like that. And that, I think it's just an antiquated
I think you're right.
terminology,
I think you're right.
and practice. Um, so I think one of the things we're recognizing is that, there'll have to be some rule changes at DCF in regard to some of these. While we tried to incorporate as much as was consistent, but there were a few things that would require that. All right, so just to summarize, folks, we're going to figure out a way to say that those are not allowable under any circumstance. Um,
And
okay.
with regard to the fire question, you were
Yeah.
asking about the keyed entry into the program. So those are
Oh,
manual
right.
locks.
I
Yeah.
forgot you said that. You said that already. Yeah. Um, and what's the staffing ratio, like at Red Clover and West River Haven at night?
Well, West River Haven isn't open yet.
Well, I know.
So I don't know what the staffing pattern exactly will be, but I can say at Red Clover, we're looking at there's three staff on in the overnights. During the days, there's at least six line staff on, and then there's, of course, the administrators, the nurse, the education
Yeah.
professionals, other people as well.
And at that, so given the cost of things, I'm going to presume it's comparable at West River Haven because
That's
given
correct.
the total number of staff and the cost, if it's something less than that, then I
No,
would
it's
be
higher.
that would be
It's higher.
Yeah.
But just to point out that this locked bedroom issue only applies to Red Clover because West
Correct.
River Haven is not it's not considered a secure residence. It's a staff secure.
it's staff
So
security.
this exception
Yes.
does not apply to West River.
Okay.
And the
Red
doors
Clover.
are not locked in the bedrooms at West River Haven. It's only at Red Clover.
It is, but Red Clover is a temporary facility and this law is not temporary. So, I think we need to think, sort of beyond,
That's right. The
what
other
our current,
secure. Yeah.
whatever other secure situation might be put in place, in the future. And I'm just going to be forthright. I'm struggling with this, on the locked door situation. And are the three staff awake overnight staff or are they sleeping?
I believe they're all awake all night. There might be a one sleeping potential. Did two awake, one asleep? I'll have to check to see if that's what they're still operating under, but I think all three of them are supposed to be awake. One
Awake.
is staffed outside the four bedrooms, so they're seated at the end of the hallway so that they can hear if any resident needs to leave their bedroom at any time.
Uh-huh. Um,
Yeah, because they don't have bathrooms in the room.
right, I
Yeah.
know, I remember that, yeah. Well, I'm interested in hearing from other people. help me make up my mind. It's not just my mind, it's all of ours. I mean, I think we're all struggling with this a little bit, to be honest. DCF folks.
Tyler, you could sort of describe a couple of the scenarios you mentioned to me.
Yeah.
About you have been coordinating at Red Clover.
So there have been some situations where we've had youth, there have been turbulent points at Red Clover. We've had youth try to arrange themselves so that they're all at the same time knocking on the door to leave their bedrooms at the same time. I think this was identified, or this came up specific to times when there was other types of elopement that was happening, or attempted elopements that were happening from the program. And then we've had situations where youth were able to, or trying to disable the locks to the door. So that was another thing that came up, where in the overnight times they would try to break the door handles so that they could all elope all at once. So there is, whatever the plans for that they had in mind, whether that was to be assaultive of each other or of staff or to elope the program, I think they're knowing that that is a vulnerable point where there's less staff on, less capacity for quick response. I will also let folks know that we do house youth with adult criminal charges at Red Clover if they're under the age of full criminal responsibility. So youths under the age of 18, sometimes we have housed youths with murder charges in that program. Not to say that the charge defines the care need of a child, but that these are youth with high acuity needs, and all of them have delinquency status.
Go ahead.
Tyler, what's the youngest a child has been there since it's been operating?
I think we're set for 14. I think the youngest or 12, but the youngest we've had in there is 14, has been 14.
Okay, I'm gonna have us move on so that we get through everything, and we'll have another opportunity to consider this when we look at the full revisions, okay? And while we were off, we realized, thank you to Matthew, that there is no definition for seclusion.
We will get one. I could have sworn I pulled it from the DCF because I remember a discussion about how it's not seclusion if the door isn't locked and the child can leave, but it is if they are under the impression they're not allowed. It's pretty detailed, but neither of us could find it during the break. If it's not in the DCF regs, it's pretty standard. We can pull one off.
Yeah, I just want people to know there will be a definition for
Yes,
seclusion.
it will come, and it's. I don't think there'll be any dispute about it. It will be a regular definition.
Okay.
Oh, okay. We do have it. She found it.
Okay, well, that's great. Well,
Okay.
We'll look at it in the next version.
Yep.
If you forward it to Katie, that would be great. Forward to
Could you
Katie and Ann.
Super.
Thank you, Hannah. Okay, where are we at, Ann?
So we are now at H. H is a consistent current reporting item. I think it may add the child's attorney. I can't even remember that, but there was
It does.
no, but I mean, I don't remember if the old one already did.
The
The old policy, this was it's in
Policy.
DCF policy, and I don't, but there was no objection to that part. The Office of Child, Youth and Family Advocacy thinks they should be also part of the 24-hour notice. DCF felt they do get notice, they do get the full report in 2 days, and that the department has an interest in making sure that it's not a report that is misdescribed in terms of categories and could be misconstrued.
I'm okay with this.
Yeah.
Yeah.
So just for
Thank
people
you.
to know that
To
there
know that
was
there
a
was a difference.
disagreement. Yeah.
Okay, thank you.
And the next one again is existing practice, but it's putting it into statute. And this is the documentation that's required. There is an addition of including access to audio or visual recordings because that's been a concern. And this was all census language, just putting it into the statute. And the Office of the Child, Youth and Family Advocate had some concerns that they testified about not getting things timely, and this is specific within 2 business days. And then there is actually also J is requiring the data to be collected about specific items, again, to require that in statute. This is not something they don't do now. Then we get to the next part, which I do need to give a little background on, and this is K and L. So the issue came up about, well, what about other places, out-of-state placements, or other programs in the state which are not under DCF regulation? Because under the language that would say child is in the custody, what about a child who's going to a non-DCF program? And DCF doesn't really have the ability to impose. I had this idea that, well, we could require them in any contract that you make for services. The contract has to apply all of our regs. The problem is that, for instance, let's say the inpatient unit at the Brattleboro Retreat, they are under all sorts of regulations by CMS and by the Department of Mental Health. And so overlaying another, that would become a very complicated interdepartmental, who's in charge of this program sort of thing. It's even more complicated in terms of out of state, because those are programs that we are contracting with because we don't have the ability to provide the kind of care that they need. And they are not readily available and don't readily accept children unless they fit their program. So it's kind of a very limited pool. And the department said, they would not be able to get a contracted placement who was expected to follow the rules imposed by the Vermont Department of Children and Families, that they are operating under their own state's rules and so forth. So that idea that I was trying to get in here, because we couldn't include contracted agencies as part of the definition of a child and DCF facilities, did not seem viable. And so the alternative was to put some statutory requirements around when they deal with any contracted placements. And this would apply to both in-state and out-of-state in the same way. This ended up as, maybe in some cases reluctant agreement, but this did end up as nobody saying, no, that's not viable. DCF was comfortable with what we ended up with. And it was preferred to what we were trying to grapple with earlier. So this requires several things. Anytime they're going to contract with another program that's not in their under their supervision, this is requiring a review of 5 years prior in terms of violations of that program's licensing status, safety of children, and a written agreement that they will inform the department directly if restraint or seclusion occurs on a child, regardless of, it actually should say restraint, not just physical restraint, because for instance, the Brattleboro
Line 7,
Retreat.
Katie.
Yeah, oh, I'm sorry. The Brattleboro Retreat is permitted under CMS to use mechanical restraint and does on children. It's another whole issue and area, but
Okay, so I have a question about
Yep.
this.
Yep.
I'm gonna put the out-of-state folks aside for the
Mhm.
moment.
Mhm.
I do not understand why a Vermont facility should not be required to comply with Vermont law. That doesn't make any sense to me.
I think we probably could choose to do that.
Yeah, well,
But I think if we did, we would probably have to hear from those other non-DCF, because if it's not, I mean, it could start being, well, this would be contracted. So it still wouldn't include hospitals because they don't contract, but they
right.
they
Yeah, I'm not-
contract
I'm
with the
not making-
retreat for beds.
Right,
Yep.
I'm not talking about things that are governed by, like CMS or their own set of rules. I'm thinking of, Brookhaven, I'm thinking of other, places in state.
Aren't they regulated by, they're regulated by DMH. They would have to comply.
Okay,
If they're regulated or licensed by DMH, I mean, by DCF, I'm
DCF.
sorry, they do comply.
and so what in-state program would this not, would these not apply to? And I'll be honest, I don't really understand because I know that as a standard operating procedure at Dale, any program that we contracted with outside of state
Mhm.
government, we put that they need to comply with all applicable rules, regulations, and laws of the state of Vermont. That's standard
Mhm.
operating procedure. Even with out-of-state, contractors. So I don't get why that can't be included in contracts. I don't.
Okay,
I'm just.
Oh,
gonna
okay,
ask the
you're
department
asking that.
about
Okay,
I'm
okay.
seeing head nods over there, so I'm
Okay,
trying to
yeah.
understand
For
better.
the record, I'm Planning Revenue Enhancement Director of Services. We do not have, any contracts with programs that we do not regulate. So so what you're saying is already in practice. Any program we are contracting with is already required to follow our regulations and rules and laws. I think there are programs where we don't have a contract and they are not regulated by us, but they are completely outside of our universe.
Okay.
Let me just keep going. When you say they're outside of your universe, do you place children there?
No.
It's, so you beg to differ.
my understanding was that there are some places where there's contracted beds for DCF custody children, and the examples would be the Brattleboro Retreat or the new PTRF, whatever initials, that's soon to open, are kind of an example of,
Right, we
or
don't
the
have,
residential school at the retreat. You don't have contracts with them?
we don't have a contract with the hospital, the
Okay.
Brattleboro Retreat. But we do have a contract for the Abigail Rockwell School, for example, which is through the Brattleboro Retreat. And so they are contracted through us and regulated through us, but the hospitals, as you know, regulated through a different entity, right?
Okay,
And
so they are contracted with, so they would, but
ARC would, Abigail Rockwell
Right.
would follow this, what you're saying.
because they're licensed.
Because they're licensed and we have a contract with them, but we don't control Brattleboro Retreat Hospital Program, and the PRTF will be regulated through Dale, I believe, through that whole process. So we will use beds there, but they won't be regulated by
Or contracted with. Okay, I misunderstood the contracted bed piece in terms of spaces. So this may not apply to any Vermont facilities. We could say, including,
But
we could make it clear that it's contracted in the state is included. Or no, you don't contract with anyone unless they're regulated by you.
Except for those examples you gave of
The retreat or the-
retreat
yeah.
So then, so when there's a youth who is sent out of state, who is, is there a contract? And do you include in that contract that provider needs to comply with all rules, regulations, and laws?
I'd have to look, I mean, they get all of the standard attachments to all state contracts.
Right.
And so there's a piece of that, we don't require that they follow Vermont residential licensing regulations. Because
Right.
but we require that they follow their own state's regulations, we require that they are licensed, that, we have a lot of language like that, and we're happy to share with you
Okay.
what that language is, if you're interested. But we don't require that they, and so what is involved, like what's included in those standard attachments goes along with those contracts in terms of our own licensing regs. We don't require that they follow.
Right, so I get that we wouldn't require them to be licensed in the state of Vermont, they're licensed in their own state. But I guess it would be helpful to understand, if there is, I guess we would like to see if you could sort of pull that up so we could see the language, like with it, you don't need to, you can de-identify it, but language that you would have for an out-of-state placement, typical language you would have for an out-of-state placement. So we can decide about, because I mean, this honestly is putting a lot of, not a lot, but because they're not a huge number of them, but it's putting extra work on DCF that, if we require them to comply with our regulations, I get the licensing is different, but the regulations implement, I don't know.
These
these
regulations, right.
Right. Then I don't think that we would need this piece, but,
Right.
so that would be great. Thank you, Heather.
A question as I look at the contract to ensure the program informs the department directly of restraint and seclusion. Trying to recollect now from the Office of Child, Youth, and Family Advocates annual report, there was reference to an out-of-state incident in Florida, I believe, where Vermont staff was required to go to Florida to view videotape. That
Yes.
doesn't seem right to me.
So-
That they can't share electronically material that's relevant to the care of children in Vermont children in their custody.
If you want, Madam Chair, I could explain what Tyler explained to me about the issue around transferring video and audio. And that's actually why even with our own, it says access to rather than physical out of states is an added piece because that's raising the issue. I mean.
So Tyler's on, so
Okay.
rather than you interpreting Tyler, I'm just gonna ask Tyler to explain that.
Right. If these regulations all were applied to a contract, what would that issue be?
Yeah, I think one of the questions is once the material is sent out of that state, out of that program specifically, they don't know where it will go. They don't know how that will be disseminated. So that's some of the concerns with sending video files or audio files attached to it. The other question that comes into play there is in these programs, there's typically other individuals, other youths being served, and that's protected information from them. So that's the other part of that kind of is the backing, and that's the argument by which they feel uncomfortable with releasing video that has other residents potentially put at risk.
So I get the other residents saying that the secure transfer, that's a outdated thought. I mean, I'm just being honest. I mean, there are many video transfers of files in secure encrypted ways that can happen. But I get the other residents, and that's wouldn't be under the purview. But if they can go see it in Florida, I'm not sure why they can't see it in Vermont. I'm not, that's not really the issue here, I don't think.
I guess I raise it because the language in here talks about being informed. And it doesn't seem like we're fully informed if some materials that may be relevant aren't accessible. It was just something that struck me when I first read the OCYFA annual report.
So there really are two, and it's a combined issue. There are two issues because the current documentation part, even for in-state, says access to rather than provide for the reason that just generically that Tyler was given. And there's no reason for Vermont where it couldn't be provided, but we just generically made it access to. But then we've encountered the problem that we're not clear that we could impose our regulations at all, in which case
Well, I guess
none of that would be imposed on the out-of-state, and that's a problem. That's what we're discussing.
I guess contractually, I'm not
Yeah.
viewing it as a regulation contractually. We've got questions about new facilities opening in Vermont and some of their practices out of state before they've come to Vermont and whether they're really adequately providing services. To me, that concern is only heightened if it's actually a Vermonter who is in a facility out of state to have access. It seems to me that there's an attempt to obfuscate something. If you're unwilling to share materials that are available related to an incident that's relevant to a Vermonter. And whether that's the intention or whether it's the intention to abide by privacy concerns, I don't know. But as Madam Chair, as you said, if you can view it in Florida, I'm not sure why you can't view it here. But
So Matthew, just a minute, and then you'll get an opportunity to, if you want to ask a question, that would be okay in a minute. I think, first off, we're gonna leave this section till we see what the department comes back with,
Mm.
to see an example of what their actual contract looks like. So we can see the language and see what we would need to do or not do. But I think you've brought up sort of a different point for me that we may want to address in this actual similar way that's outlined here. And that is prior to contracting with an organization to run a state program, that type of review is done, that type of overall review is done. I'm just going to use the example of West River Haven. I think we all got some questions about the entity that was contracted with. I think that we do want to make sure that due diligence is done prior to contracting with an organization, whether they're in state or out of state, to run a state-funded facility.
Is that covered in?
It's not really.
Part of K?
I didn't.
Well, they are licensed by the state, and it may be that we want to say for state license programs, we want them to do this review in advance.
So
Which was
we
not
are tra-
considered.
right? So
Yeah.
we have moved away from state employees providing these kinds of services. So we're going into what some might consider. I think there's debatable, but some might consider a higher risk situation when we're having to contract, and particularly when there's very few entities out there who perform this kind of function. And so I think that Vermonters need to be assured that due diligence is happening prior to those contracts
Mhm.
being entered into.
Mhm.
So I guess I'm not feeling like it's explicit enough.
So I think that needs to
in
be
that
its
way.
own section, because this
Yeah.
wasn't even contemplating that specific.
I realize. it
Yeah, and
wasn't.
I can work that out with Katie, because it'll be a little more than on the spot.
Yeah, I mean, that's just the thing you brought up for me, Doug.
Yep.
Was that, I'm still not sure that we've been convinced that that was sufficient. And we only know what we read and what we Google.
Yeah, so this is requiring that pre-review before contracting
Yeah.
for anybody to be running a program,
State license
even if it's
program.
licensed.
Yes.
Right,
Yeah.
yeah.
Okay, Matthew. You have a question?
Thank you, Madam Chair. Well, I wanted to provide some insight to the committee on this issue because I think it is really critical and maybe one of the most
Okay,
important parts
Matthew,
of this bill.
Matthew, I'm really sorry, but that's, we're not taking testimony.
I'm not trying
Okay.
to testify. I'm trying to provide responsive feedback to what was already said, which is that this has been a critical issue, including this week. Regardless of what the contracts say, it is rare for DCF to request or obtain a copy of a video. And the reason why we know this is an issue is because this is a central piece of our office, and we have asked multiple times for these videos, and we have not gotten a single one. And it is not, I don't think, because of ill will on the program. I believe it is because of sort of general liability legal advice that these programs get, which is not to share these videos. This issue of there's other kids in the video happened this week on a request we made. And I think, frankly, it is a convenient excuse, but I don't think it's a real issue in 2025. 2026. It is very easy to obtain software to blur the faces here. So, Madam Chair, to keep it relevant, and I feel a little tense here because I don't feel like we're getting the same chance to speak on these issues as DCF is, and I think this is critical to our mission, and to the reason why you created this office. But this is just a key issue, and requiring programs to provide the videos, I think it is a key contracting issue, given how much money we're spending, how much general fund, how much taxpayer money we're spending, given the critical child safety issues here. And I think that the committee should not move too quickly to say this is not possible. I think it is quite possible, and I think it is critical to this part of the bill that it be a requirement that if the state of Vermont, and if we are contracting for these services, that if there is a video, it should be provided. I think that should be a baseline. So I appreciate. I also have some data that's responsive to the question about the ages of kids at Red Clover, but I will let you request that. But just so you know, thank you.
Does it differ from what we were told?
So quickly, the youngest child by our data placed at Red Clover was 12.4 years of age. Then there were 2 13-year-olds and 8 14-year-olds that have been placed there through the end of calendar year 2025.
Okay,
That's it.
thank you. Thank you for that clarification. I'm seeing Tyler nod his head.
And I want to verify that that is accurate. I ran the numbers too, and I misremembered that 12-year-old. And so I apologize for my earlier testimony or
Thank you.
earlier answer.
Thank you. Thank you. Okay, so we're gonna put a hold on this for right this moment, because we're gonna see the language that's in the contract. And I think that I think what Matthew is presenting is actually a bit of a different issue. And I'm not saying that it's not something.
It's connected.
It's
but different.
connected,
Yeah,
but
yeah.
different. And maybe we should address it here. But I also, I want to see what the contract looks like first. Okay.
Because the underlying question is, what can we impose as part of a contract on out of state? And that's what we're looking, which would then maybe include this
Yeah.
as a piece of it.
Yeah.
But it's,
Okay. Thank you. Okay. Then we're on L.
L is connected. L is what happens if there's an out of state that's not subject to the rules, but is violating evidence base. So this is really connected with K and L are together with seeing what they.
Yeah. And I will say again, well, I guess I will just wait, but I know that it is very possible and very common practice, even when you're contracting with somebody out of state, say you have to abide by the department's rules.
Yeah.
So I don't really buy this, not subject to the department's rules.
And I would be very happy to be corrected and learn that.
I'm not saying you're
No,
going to
no.
be corrected. I'm just saying.
But corrected with what I understood
From them, yeah.
right.
So, okay. So
Well, great.
K and L
We're
are
walking
connected.
into the next and actually next to final one where there was a significant disagreement.
Okay.
This section is specific again to the residential program, the secure residential. So Red Clover and a future secure one, where the department, everywhere else, the standing rule from Part A, subsection A, is no mechanical restraints. The department was very concerned about a complete ban on mechanical restraints, and described, as they did with the locked doors, some particular situations where it could be really important. And the specific thing was where they had to do an immediate physical restraint, but that with an older youth in detention, then getting that child into seclusion, which is generally perceived, seclusion is less restrictive than when you're restrained. You can move around in the room, you're locked in, but that what they have done and what they think is important to be able to do, because it's rapid and can move the child to seclusion, to less restrictive rapidly, is to put handcuffs on that child to then transfer them to seclusion. And without being able to do that, moving them from another space, in physical restraint, they just, wouldn't be able to do that to get them to, so they'd have to stay in physical restraint for longer. So that was the concern they had. And so that's why this was written as a potential, an option for the committee to consider, which is worded for the minimum amount of time required to enable relocation to the child to a less restrictive means of intervention if necessitated to prevent serious and immediate harm. And this is one where the youth and family advocate strongly opposed having this.
Yeah.
So that's on the record in terms of that issue.
So, Tyler, sorry, I keep putting you on and off. I'm sure you're trying to get other work done.
I'm present. Chair.
Do you have data on the number of times that this has been, this circumstances have been required to be used?
I'll have to compile that data. I know we had no mechanical restraints for several months of operation, but we have had mechanical restraints used several times since. So I'll have to compile the numbers of how often that is. It is typically, as Rep. Donahue used to describe, to transport a youth from a milieu where there's others present into a space of their own where the restraints are immediately removed.
I would make note, I think it's important that this is not permitted under current regulations, but is being done at Red Clover per the testimony.
So I guess my question is, how, I'm wondering like, why this is necessary if we already have the exclusion for the child's safety?
Not for mechanical restraints. There's no exclusion for
For
mechanical.
mechanical,
restraints.
okay.
This is mechanical because it's using handcuffs. And the perception that even a soft restraint would not be rapid enough to do it. So this is very specific to.
Okay, and Matthew, what are you seeing as the objections to this?
I'm sorry, Madam Chair, could you be specific about exactly which section and what you're talking about?
We are on page 25, line 14, section M, paragraph M.
Thank you.
It's talking about the use of mechanical restraints to move a child into seclusion, essentially.
And what is your specific question?
Representative Donahue was saying that this was a point of contention and that your office was had concerns about this.
Yes, I mean, I think it's the breadth in terms of the way this was written. You know, a child detained in a secure residential program may be restrained with mechanical restraints for the minimum amount of time required. You know, that section in particular, you know, who decides that and exactly what that means. I mean, I appreciate the intent of the language, and I think it's, you know, it's a good starting point. But I think that was our concern, was just whether this was written in such a way that it wouldn't actually provide the protections that it is designed to protect, because it's just not specific enough.
So the thought is that minimum amount of time is subject to interpretation.
Correct.
Okay, thank you.
Thank you.
Can anybody think of something that's more specific, but
Briefest amount of time. We use language for, where was the other? Oh, the prone restraint.
to turn them over or to,
Yes, that
Yeah.
we used is the term used,
let's cross-reference the prone restraint term phrase that we used.
Okay, I
I don't know what it is.
momentary initial hold.
a momentary initial hold.
Is that what you want to say?
Momentary is more specific than minimum. It's consistent.
It matches.
It matches language that we've used. Okay, all right, move on. And just as an FYI for folks, I know there's a lot of stuff happening at lunchtime today. If you're involved with Farm Bureau Luncheon or the early childhood education folks. So we're going to break at 11:30 today, okay?
Okay. N is a strip search. And this language, as it ended up, I think did not raise significant concern, because it is very constricted. This is the other exception specifically for secure residential programs. And this is the strip search. And it requires that it can only occur after a pat search. So it's not just, well, we have a hunch this kid, or we have a suspicion that they are carrying. And it's not just any contraband. It's not cigarettes that's contraband. It's something that poses the serious risk of bodily harm. that at that time, if there's probable cause to believe it, not just a suspicion,
Mhm.
and the child is given the opportunity before and at any time to simply turn over the
Mhm.
contraband that showed up on a pat search. But if all those things happen, then there can be a strip search occurring.
Katie, on line 4, I think it should say harm to the child or others
Oh, yes,
instead of another.
great.
It says another throughout.
Oh, I
Oh,
thought
it
it
does?
said,
I think so.
Really?
yeah, I think there's a lot of places where it says
Child or others.
others.
Well, I'm just gonna flag it. We don't
Yeah.
need to
Yeah.
spend time on it.
I have it about 8 times, another. I'll figure it out. Do you have a preference? You want others?
It feels like it should say another child or another
Or
something.
others.
Another child and other, or another person,
Others.
when
Yeah,
it's
Okay.
That's why I
it's
just think using,
another person,
Right.
not another,
just
just
want-
another.
I think it should just say others.
Others?
others. is-
Because it could be staff. It's not just other.
I guess I hesitated from using the plural because it implies that they have to be hurting multiple people instead of risk of hurting one individual.
So Katie, both are used right now. So right now.
Okay, so I
we
can go
have
through.
Child or others.
Yep,
And we have child or another person.
okay,
So it should be consistent.
Yeah.
Either one.
you don't care. Okay,
Could others include just one person, up to one person?
I mean, potentially the plain meaning, I don't know, I was getting stuck on it.
Oh,
The
yeah.
plain meaning was plural, and so do we have,
Yeah.
Does that-
Clarity seems to be.
Yeah. I will do another person and I will change it throughout. Does that work?
Sure.
Probably, but I can't tell really without going back and looking, but go ahead and do it.
Okay.
If it makes sense to do it, if others make sense when you go back and look at it, that's fine too.
I think the current regs all say, I think the standard is self or others, to the child or others, but
I don't think others necessarily means more than one.
Yeah.
Like, you're.
it's any other. It
Yeah.
means the same as any other, others.
Okay, I will use others.
And it's long understood that way, so I think it's,
I think it's fine. Okay, and no body searches, body cavity searches. Yeah.
right.
Okay. Rules, we're up to rulemaking.
So obviously, all of these are backbone outline. They don't go into the details, doesn't detail staff training requirements or supervisory oversight. This is just saying there has to be rules adopted. Although they have current rules under the licensing standards, there's a lot of changes that would be needed. And this is saying there needs to be a rulemaking process for this. Whether they want to keep them cross-referenced as being in licensing. Right now, you can't even find them. I dare anyone who has not heard where they are to try to find them.
I was gonna say, you just told us where they are.
Yeah, I know, but if you didn't know that, if you search under, restraint or seclusion, any of that, it's very difficult to find because they are only under the licensing standards. So, at any rate,
And we are talking about portions of this being applicable to entities that are not licensed by the department.
Exactly.
Yeah,
yeah.
so that might not be. a
So the
lot.
licensing regs could say, and everything in the restraint and seclusion regs,
So, and the only other thing that I want to, is just to add, in section O, it's a finite list, so I think it should be say, other, some catch-all for anything other. There might be other things that should be included in those words
Oh, okay, yes.
Second. that just aren't listed there.
Implementing this section, that's right. It shouldn't just be implementing the section. It should be,
Well, it says including, but I know that sometimes departments say, well, you told us to adopt them in these areas, and that's what we did.
no, you're right. Including is supposed to mean.
I know,
Yeah,
right, that's what
right.
we think in legislative
Yeah,
language, but
yeah.
it's not always interpreted that way.
Okay,
So I just think we should say an
Or
other
any other necessary
necessary. Yes.
standards.
Yeah.
right.
And we've already done,
We've done all of the,
or we'll be adding a seclusion one.
yep.
Okay, all
So
right,
now
report.
we're all the way to the report. So this was, big picture, original, if you recall what you last saw.
Page
which-
28, line 12. Just
Yep.
focusing people.
Right, we had another bill that had to do with solitary confinement that was actually really focused on children who were in correctional facilities. We realized that was a big topic of its own. But there was still an interest in saying, you know, those should be looked at, particularly what things are we doing here that might be a practice that could be adopted. And so this proposal says a written report from the two departments to discuss restraint and seclusion, and the fact that it can cause physical or psychological trauma, that they would confer, write a report, take input, consult with a work group. So both the Department of Children and Families and Department of Corrections are very amenable to this. And because this is exclusive, this is really the Committee on Corrections and Institutions jurisdiction on anything having to do with the Department of Corrections. I did present it to them just this morning. They are fully in support, that it's a good idea to do. That's basically what it is. Questions?
No.
Like that.
Yep. The last one in this section is making the rates public. There was a part that I had in this that you've never seen that was removed, which the Office of the Youth Advocate does not like it having been removed. And I will say this idea, which had not been in the bill at all before, was that the Department of Mental Health does this for restraint and seclusion in hospitals, where they're also trying to reduce them and minimize use. And it reports them by hospital. There are 5, I think, that have involuntary patients. So this suggested both posting the overall rates of restraint and seclusion, and the numbers of uses of secure transport and restraint on the website. There's a part of every website in the Agency of Human Services, a scorecard piece that gives leading data on leading indicators.
A lot of them are very
quality care.
outdated.
Yeah. So this would add that indicator, and originally also said by program. And there was real concern by the department. Of course, there's a lot more programs that they license. There's a lot of range of programs in terms of ones that only admit children who are very stable, who need support for a while, versus highly troubled children who are maybe much more potentially aggressive. And so putting that data based on the program name without broader context, people could say, oh my gosh, look at that awful program, all those restraints. Look, these guys do it with none at all. That is not a good idea.
Yeah.
I did not disagree with that and took that out. The Office of the Youth Advocate thought that it should be included.
So,
but it's a new requirement. I
think I would go with your interpretation or your recommendation on that. The one question that I have, because there are elements of this that are just for residential programs, but then there are elements for any program licensed by DCF. And so why are we just limiting the report on seclusion and restraint? Or it's not, doesn't do seclude, oh yeah, it does, to just residential programs? Wouldn't we want to know?
Any program licensed.
Because they're required to do it.
Yeah. No, that was not intentional. That was, it was not intended to restrict it.
Yeah.
It's a good catch.
Yeah.
Change residential to licensed programs.
Yeah.
Licensed by.
Do you have any concerns with me moving this to the section on seclusion and restraint instead of having it in session law?
Oh, right. No, it should be on this.
I'm seeing it with fresh eyes and
Yeah.
I feel like it belongs there. Okay, I'm gonna move it.
Yes, thank you. Yeah.
Yeah, I just got to talk to a sheriff that's actually working right now. He said to let you know that 12-year-olds sometimes are bigger than them. Okay.
And then we've got 10 minutes before we look at revisions. We might as well, I think, Madam Chair, go to this last part, which has nothing to do with restraint and seclusion.
No.
But it was the one very short other part of this bill that I had worked on. And this was the subject, we had testimony on it, about the loss of federal money because we didn't have a juvenile oversight, a court oversight, family court oversight of some type over these programs, maybe very minimal. And the bill started out saying thou shalt start a program and thou shalt work out the details. And that all seemed very premature. And so this was rewritten to be much less specific, just more general, consistent with what Judge Zone had said they'd be happy to do, to talk and to just say, come back with a report with recommendations for court oversight processes that meet federal requirements to allow access to federal funds for programs. So it doesn't even name which program, but because the Department of Children and Families is much more familiar with where that might make a difference for accessing down the line. And it was discussed, this isn't something that can happen right away, but we can find out ahead of time what might we have to do, because it would have to be done in statute to change the jurisdiction of the court.
Okay. All right. So we've gotten all the way through this bill. And Katie, thank you for sticking with it. When do you think we might be able to see another version? I know you've been making changes as we go along.
Yep, you can see, I mean, I could probably just give this a review, send it through editing and have something for you. Are we coming back at one?
We
No,
are.
But I'm not.
But
Someone else.
here, we're doing pre-K.
Okay.
at one.
So that would give enough time for the editors to look at it. The piece that I'll just highlight in green is the piece that you haven't sorted out yet with regard to the out-of-state facilities. So there, I'll just have a placeholder.
Okay.
Right.
And we need to talk about the department's feedback from this morning. There's a memo. We can use this next few minutes to do that.
You want that appropriation out on the next draft to?
Also the interstate compact
Yeah. That's
language
it.
you added, you put it in the SSI section, it looked like.
Yes, that's where it is. I saw that.
Yeah.
Did I?
Okay.
I'm
that's-
sorry.
Yeah, no,
It's on my
just
list.
wanted to, I
So
figured that.
where? Which?
It should
section?
be in the unaccompanied homeless youth.
I put it in SSI. Okay, I will. sort
It's
that
down the
out.
bottom.
Thank
It's the last number.
you.
Okay, so that on our website, you can see the department's feedback on the version up till today. And a good chunk of it has to do with the SSI implementation and phasing of that. So Dan, you have some thoughts?
Yeah, so basically my thought was in C1, which is establish the trust for the children qualified
Can
able
you refer us
account.
to a page number?
Oh, yeah, sorry. Almost there. Right here. So it will be on C1. Okay, page 4, line
I haven't gone back far enough,
Okay.
obviously.
line
Okay.
7-ish,
Okay,
somewhere in there.
okay,
Okay.
okay. Yep.
So let me go back to my other document here. So to create a new one or two underneath that. So basically establish an account for the ABLE account. So children that are receiving disability benefits, start putting that into an ABLE account right away. And then secondly, survivor benefits, any child receiving RSDI benefits other than funds eligible for ABLE accounts. Department should conserve those benefits in a manner consistent with federal requirements in the children's best interest, but delay this for 1 year. So this would be the second half. In that time frame, the department shall implement procedures for the conservation of these benefits to develop financial literacy in conjunction with other stakeholders. Unlike, it could be the treasurer's office, the Office of the Child Advocate, a child, youth, and family advocate. And I've actually talked to the Vermont Bankers Association, and they would be interested in helping with financial literacy or what this whole work.
Community action agencies do that as part of their regular
Correct. Yeah,
business.
yeah. So can we just say, over the course of the next year, implement conserving these benefits by 27? So the ABLE ones right away. So this would be way down the bottom of the bill where we put the different timeframes that it's implemented. One would be, which would be section 1, C1, would be right away, and then C2 or whatever it works out, I'm happy to work with Katie on this, would be following year.
Okay, so, yeah, so yes, I think that, so why don't you work with Katie on that language? And I'm not sure that addresses the whole issue that DCF was raising around the, on the SSI part of it, you know, with regard to needing to think about that at, and I think you had maybe even mentioned this to me before, different ages.
So instead of phasing it in over different ages,
Yeah,
I was saying just break it into 2 chunks. So the first one is people that are eligible for an ABLE account. That would be done right away, and then the
that's
rest of
the
it.
concern that they have, though.
Correct, because the
Okay.
concern is the money,
Exactly.
right?
Well, and we can't create a hole in the FY 26 budget, so that can't be effective July 1, 26.
Okay,
But
so maybe it's,
I think they both need to be.
put them both.
Well, because the reason I'm saying that is because they need an opportunity to budget for it. And the budget's already been submitted. So I. What you were, so I think we would be,
That's, I was initially just saying, we'll figure out the able ones right away, but if you think that's a better thing to move it both out a year.
I think I think that whatever the 4 initials are.
Yeah.
The survivor, that's actually an easier one to implement because there's much fewer of them.
Correct.
So if we wanted to implement one on July 1, it would be that one.
Okay,
And then the able ones.
The
would be a
able
year
ones.
Later. Let's try that.
So let me just see where we are.
Yeah.
Does section 3 of the bill takes effect July 1, 26, but C1 and 2 don't take effect until July 1, 27. Is that what you've decided?
The SSI part, yes.
So C1 and 2. Okay, so that means the section will be repeated twice to amend a year later to add those 2 subdivisions back in. So you'll have a new section of your bill amending the section you created in section 3.
You can't just say it takes effect on a different date?
Not within the same
not
not within the same
section.
subdivision, yeah.
Break it.
Yeah, because it's all
Refer
embedded
to
in.
the sections and not like internal in the section.
Yes.
Yeah, I'm trying to read, I got some more information here.
Okay, all right, so, so I'm not sure about that. Because that adds confusion in a bill for people. I get the need to do it. So I'm just, wondering if we can just,
Make the whole thing start in 27. Which would allow the budgeting to happen.
yeah, why don't we do that?
Section 3 is 2027.
Yeah. It's cleaner. It's less confusing.
Okay. That whole section would take effect.
July 1, 27.
Okay.
And we'll get a fiscal note.
Nolan is working on a fiscal note, yes.
Right.
Okay, all right, that's gonna wrap it up for right now. Okay, we'll be off until 1, at which time we'll be back in room 10 downstairs, to take up a whole different